Good day and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we're talking about Jack Daniels, Mickey Mouse, Andy Warhol, Jason Voorhees, Lizzo, and WallStreetBets. What do they have to do with patents, you might fairly be wondering? Honestly, not much. Patents are our focus in our business and in this podcast. We devote a lot of airtime to talking about protecting ideas and inventions. But in the realm of intellectual property, patents have some pretty close cousins that we'd like to discuss today. In thinking more broadly about creating the largest possible moat with your intellectual property, you also need to be considering what our guest today refers to as brand protection, or the copyrights, trademarks, and contracts necessary to protect your brand's rights and assets. Copyrights and trademarks in particular have seen a lot of limelight this year, involving some of the biggest brands and pop culture icons. At the same time, major IP rights questions are erupting around the use of generative AI systems like ChatGPT. In addition to covering some of the basics necessary to help get you booted up, we're going to use these high-profile topics in Supreme Court cases as a vehicle to get a deeper understanding of copyrights and trademarks and some of the sharpest corners you should be aware of when managing your own brand protection. Since this is not our bread and butter, we've enlisted some great help today. We're very pleased to be joined by Mallory King, a good friend of the podcast who's also helped us with some of our own brand protection, including copyrights for our beloved Sonic the Patent mascot. Mallory is the owner and attorney at Breathe Brand Protection PLLC, a boutique law firm specializing in all things brand protection. Based in Traverse City, Michigan, Mallory is passionate about helping entrepreneurs and small businesses protect their most valuable brand assets, both locally and nationwide. Mallory received both her JD and BA in political science from Michigan State University, but nobody's perfect, so we don't hold that against her. Go Blue. You can learn about Mallory and her brand protection legal practice at breathe.law. We'll be sure to include that link in the show notes. Before jumping into our interview with Mallory, we'd like to take you to the second installment of the Mossoff Minute, a new monthly segment that builds on our Patent Wars episode and features short conversations with Professor Adam Mossoff, providing updates and quick takes on movements in patent reform, significant court rulings, innovation policy happenings, and occasional Star Wars references. This month, we discussed the introduction of the 2023 Patent Eligibility Restoration Act, its biggest criticisms, and why it needs to be passed. First question is just, we attended a recent U.S. Inventor call with Judge Michelle. Judge Michelle was super generous with his time. It was a very long, super constructive call. And I don't know that U.S. Inventor is officially taken a position on this yet. They tease that they might be soon. But like I said, super constructive conversation, but there were some lingering concerns. So, the judge said that, I think his quote was, "Process is the tricky one." This version got rid of the term non-technological, which was definitely one of the bigger hangups that we talked about, with the prior version. The judge tried to clarify, and he said that, if a computer or machine is involved, that it's essentially eligible, but if the process is done with pen, paper, or mind, that maybe not. The rationale he gave is sort of like trying to set aside things that are cultural, artistic, or aesthetic in nature, and that they're
business.
really
I think business is one too.
Purely business.
Yeah. And so they're trying to draw this line between things that are technical and non-technological in nature without necessarily using that term non-technological, because on the basis that the patent system was historically meant to cover things that touch on technology. But there were some, pretty reasonable concerns that were expressed around, potential for unintended consequences, right? The phrase keeps coming up, with process language, because things like the BCD algorithm. This was an example of something that was, highly technological in nature, but that could be thought of in the mind and done on paper, right? So just given the volume of discussion and the questions that arose from, U.S. Inventor members during this particular call, I think that demonstrates that there's still some room left for, interpretation around these things. And so we know that's where the courts have gone wild in the past. So the question is a long lead up, but the question is are these concerns sort of just, misunderstandings, or are they really just sort of the inevitable casualties of compromise and getting to a system that's infinitely better than what we have today?
Yeah, that's a really great question. And let me reframe it a little bit by first recognizing and identifying that we have a serious problem in our patent system. The U.S. Supreme Court has turned our patent system on its head and has reversed decades, if not centuries, of a general approach within the United States of securing new innovations in the cutting edge areas of the U.S. innovation economy. Processes were part of that, and a very important part of that in the Industrial Revolution, and even in the biopharmaceutical revolution of the 20th century, and they continue to be in the biotech revolution and in the high tech revolution of the late 20th and now 21st century. So we definitely have a problem. It is a very difficult area to identify with analytical precision and conceptual precision. Exactly, well, if you're protecting steps that do something to achieve something, which is a human innovation in itself, and that was as we've talked about in the past, was a improper innovation of the founders to recognize as something that should be a patentable invention, as distinct from and refusal to recognize that in England and in other countries. It's important nonetheless, to recognize that we should continue to try to protect these issues. And so people who are concerned about that, there might be some restriction or undue restriction on the ability for people to obtain process patents. That's a legitimate concern if they have that concern. But I don't think the concern in this context is coming from the right place, in the sense of, legislation will never be bulletproof. You can't write a piece of legislation that can never be misinterpreted by courts or misapplied by courts or even the U.S. Supreme Court at the end of the day. If that's your standard, like we can only enact a bill that will provide us with 100% certainty that a court, whether a district court, whether the Court of Appeals for the Federal Circuit, or whether the U.S. Supreme Court, will never, ever be able to misinterpret this. Well, that can never happen. And we would never have legislation. Now, maybe that's a good thing. Maybe people don't want Congress to be enacting laws, and that would be, and frankly, I take that position with respect to a lot of areas, but we do need Congress to enact patent laws. So, because there isn't any patent law if we don't have Congress enacting patent statutes. So that can't be our standard with respect to patents. And what you try to do is you try to address that, and you try to cabin in as much as possible, by writing, precise statutes, and setting forth now what has become a normal practice, which is findings in the statute, because that makes it very clear what Congress, in enacting the statute, means in the actual statutory language itself, which is really important, because you don't want courts engaging in shenanigans by picking and choosing pieces from legislative history or offhand comments by particular senators or congresspersons as to what they think the legislation meant, because Congress enacts the legislation, and if the legislation includes findings, and that's part and parcel of the public meaning of that statute. So I worry that there's kind of this concern about perfection in enacting legislation that is driving some of the criticisms of patent reform legislation more generally, and that kind of classic adage of letting the perfect become the enemy of the good is really undermining the ability for us to actually enact legitimate, necessary patent reform legislation, because the Patent Eligibility Restoration Act is really important. By and large, it is the best, piece of proposed reform we have at the moment, and I don't see any others. And unless someone has an alternative bill to introduce that actually is better, then we need to go with the legislation that we have, and the legislation that we have is pretty good. Now, are there aspects of it I don't like? Yeah, I think it's a little too detailed. Or more precisely, I think it's too much detailed. I prefer kind of more general, broad language like you see in the 1952 Patent Act. But, notice people could have the same criticisms of that general, broad language that they have of the current Patent Eligibility Restoration Act. Oh, that allows for shenanigans by courts because it's too broad, right? And so you can kind of see how, senators feel like they're caught in a situation where it's no win for them, right? If they write legislation that's too broad, they get attacked that doesn't actually cabin in the discretion of courts. So they try to be more precise. And then they get criticism from people like me saying, you're right, you're doing too detailed statutes and you're not covering it. And they still get the criticism from the people who are saying this still doesn't, prevent courts from engaging in shenanigans, because at the end of the day, you can never fully prevent that from happening if judges really want to do it. But what you can do is at the core make clear what inventions are patentable and are not patentable. And the Patent Eligibility Restoration Act, achieves that in the best way possible in our current context. And so for that reason, I think we should support it. And until or unless someone actually has introduced a piece of legislation that is better, actual legislation introduced, co-sponsors, that is better and demonstrably better, that it isn't susceptible to the exact same criticisms that are being made against the Patent Eligibility Restoration Act, then I think we need to talk about why we should be enacting the Patent Eligibility Restoration Act. It's always easy to harp on and criticize, on the edges. It's not the edge cases that should be driving you. What should be driving you is, does this address the core issue that you're concerned about? And what are we concerned about? You can't get patents in biotech right now on DNA and on diagnostic tests and on all the things that have wrought our incredible biotech revolution and have made medical treatments that were thought of as pure science fiction even just 20 years ago that are now standard today. You can't get patents on high-tech innovations, on computer software and CGI and on AI now. AI is starting to be, held to be invalid because, that's just human thought. And meanwhile, you are getting patents on these things in China and Europe. So is the United States, where do we want to be as the United States? Do we want to be the leader in biotech and in high tech and AI and, automated cars and all these things, or in 5G or 6G? Or do we want China and Europe to lead on these things by where they secure to their innovators these types of new innovations? So, I think this is a fundamental choice that we have to face and recognize. And I think the PIRA Act, as it's come to be called, addresses this quite well. At the end of the day, we need to reform the patent system. We need this important reform. It's not going to come from the U.S. Supreme Court, which has now denied well over 50 cert petitions to ask it to reconsider its application of we now refer to as the Mayo-Alice or the Alice-Mayo framework. And so the only last place it can come from is Congress. And Congress is doing its job, just like it did its job in 1952 in overruling the flash of creative genius tests that was manufactured by, I believe, Justice Douglas. That made it impossible for people to get inventions under what was then known as the invention test, and becomes known after 1952 as the non-obviousness inquiry.
We're also publishing clips from the Mossoff Minute as short-form videos on Instagram Reels, YouTube Shorts, and even TikTok, at least until we're shut out by big tech or the Chinese government. You can check out these shorts and follow us at Aurora Patents on all 3 platforms. And be on the lookout next month for some great analysis on the recently introduced Prevail Act. Now, without further ado, here's our conversation on brand protection with Mallory King. Thanks for joining us today, Mallory.
Thank you so much for having me, Josh and Ashley. It's a pleasure to join you.
Didn't even fight back on the MSU dig.
I would say go green, go white. But we can all be friends.
We can all be friends. That's right. That's right. All right. So, we're hoping to cover a lot of ground today. You don't get to say this often, but it's been a very busy and especially poppy year for copyrights and trademarks. Lots of juicy topics to get into with Jack Daniels, Andy Warhol, the mouse, AI taking over the world, all these things just really being the tip of the iceberg. But before we get into all of that, we think it would be helpful to lay down some groundwork on the basics of copyrights and trademarks to help anyone in the audience who's newer to those IP asset classes.
Awesome. Thanks, Josh. So Mallory, I think it would be helpful and kind of was some of the original inspiration for this, for this episode was to kind of give everybody a good 30,000 foot level view of what copyrights and trademarks are and what they're designed to protect, what rights they give to their creators, and then obviously some good examples of each of these.
Absolutely. And I think starting with the basics is a great place, especially because, as you know, with patent, the intellectual property space can be quite complex. And so with copyright, this is what protects artistic works fixed in a tangible medium of expression. So you're going to think of books, plays, music, both the notes and the lyrics, photographs, fashion designs, paintings, jewelry, graphic designs, TV shows, movies, blog posts, social media feeds, etc. Anything that is being created physically and put out there artistically. Notably, the one exception is that you can't copyright an idea, because this is something that is intangible and not fixed in a medium of expression. So with your copyright, and as a copyright owner, you're given several exclusive rights to that work, which includes to reproduce, distribute, display, perform, and or create derivative works of that copyright. And conversely, trademarks protect words, slogans, and or logos that are used or intended to be used in association with goods or services. So a trademark in and of itself is meant to be a source identifier of goods and services. So the trademark has to be used in association with those goods and services. And so this is where a lot of people can get tripped up. And even some of my clients who come to me, they don't quite understand that the trademark has to be that source identifier. So for instance, you can't just put a trademark on a shirt and have that be protectable as a trademark. That would be what is called a merely ornamental use of a trademark. Rather, you have to establish use of that trademark in association with shirts, so this is either by having a website where your trademark is featured and you're selling the shirts, or sticking a tag on the shirt that has the trademark so that they know the trademark is the source of that shirt. This is what we call a specimen of use in the trademark world, and it's imperative to getting trademark protection. And like copyright, as a trademark owner, you also are given exclusive rights to the trademark, specifically on a nationwide basis, since it is federal. And also you have the right to prevent others from using a confusingly similar trademark in association with similar goods and services. So as a trademark owner, it's actually your duty to enforce your trademark rights against infringement. Otherwise, you risk your trademark becoming less strong in the marketplace. And when you're looking at trademarks next to each other, comparing whether there is confusion, the basis is likelihood of confusion when comparing these marks. And this is a very fact-intensive analysis. There are several factors that can be considered, such as the dissimilarity and dissimilarity of the marks. And this could be anything from sight, sound, and meaning. The trademark office has been known to even refuse translations of words if they're used for confusingly similar services. And also they're going to look at the nature of the goods and services, of course, the trade channels used, and things of that nature. Essentially, the question becomes, are consumers likely to be confused about the source of these goods or services when they're looking at the two trademarks? To give you some concrete examples, trademarks are everywhere in our consumer-centric society. You can look at your shampoo bottle in the shower, any of your products you use, trademarks are amongst us. So some obvious examples would be Nike. That's one of my favorite ones. Nike has both the word and the swoosh symbol trademarked in association with a massive amount of goods, athletic apparel, t-shirts, you name it, they have a large portfolio. Bath and Body Works is a trademark for skincare goods, beauty products, Kraft in association with food. So, you think your mac and cheese, your salad dressings, anything that Kraft might distribute. Apple, and that's a big example, in association with technological goods. So, and this one is particularly strong because it's very arbitrary. It has nothing to do with what it actually provides in association with that trademark, which makes it stronger. And then you also want to think like words we use every day, right? Google, Pepsi, Facebook, Kleenex, Clorox, these are all trademarks. So they're everywhere.
Awesome. Thanks for that, Mallory. And so you mentioned, that you can apply for these and that it's federally regulated. So can an inventor or creator get protection for these all in one spot, or are there multiple spots that they can go? We usually think the United States Patent and Trademark Office, but that's not really the one-stop shop for things, as you know.
Absolutely. So yes, the USPTO is where you go to protect your trademarks, just like your patents, but the copyrights are registered through the Copyright Office, which is a federal agency that oversees the organization, registration of those copyright applications. And it's important to note that it's not required to register your copyright or your trademark. It's just extremely wise to do so. And so under the common law, taking aside registration at all, right? Under common law, copyright is actually automatically created when it's fixed in a tangible medium for the first time. So say I sit down, I create a piece of music, I make a painting, I have automatic common law copyright to that work. Trademark is similar in this regard. They do recognize common law rights, but it's typically limited to geographically where you actually use the mark versus having the federal nationwide protection with the registered mark. So an example that came to mind for me was in law school. We talked about a Papa John's pizzeria that was local in a town, and then the big, huge company of Papa John's that's nationwide tried to prevent them from using it. But this pizzeria had actually been there before the big Papa John's, and they had those common law rights to their geographical area. So they weren't infringing, they could coexist. And it's noteworthy in that regard on that is that the trademark law does recognize the first to use versus the first to register when it comes to trademarks. So you could have a common law trademark usage that's pre-existing to an application that could actually oppose that application, right, on the grounds of being there first. But again, you're going to be overcoming hurdles of how prolific is your use of this mark? Where are you using it? The trademark office would want to see a lot of evidence that you're very well known by that mark to have like any sort of common law leverage. But overall, I always recommend registration whenever possible. And this is for two main reasons. It is to put other people on notice that you own the copyright or the trademark, and to enhance your enforcement options. So, and in general, IP, as you guys know, can be extremely valuable asset for a business, particularly in a mergers and acquisition situation. So if you're a business, it's really important to think about acquiring registration to your IP so that if you did get bought, you can say, I have this whole portfolio of registered intellectual property that is extremely valuable to the company. And so when it comes to enforcement, in order to even sue for copyright infringement under the Copyright Act, you must have a registration. You can't have a pending application, has to be registered, registration in hand. And this is something that the Supreme Court actually ruled on specifically because they were getting a lot of cases where someone would apply for a copyright and then sue. And then it would be TBD whether they even have a registered copyright and can take advantage of this statute. And the Copyright Act is important in this regard because you can get statutory damages. So damages that are written out specifically and limits are articulated in that statute. Whereas if you have your common law copyright, you're only, allowed to enforce under state law, and you're going to have to prove actual damages based upon that infringement. So you have to gather sales data from them, articulate actual hard evidence of the damage caused, which can be extremely burdensome. So it's always good to have that, benefit of the doubt, right? That I have a registered trademark, you're infringing it, I'm entitled to a certain sum of money.
No, I think that was great. And I think, to underscore the difference between patents and trademarks and copyrights, right? patents you have to file first before ideally publicly using. On the opposite side of that, copyrights and trademarks, you basically do need to create them and you do need to use them before you can actually get them registered. So I think that's a really nice contrast. So where does trade dress fit into all of this?
Well, trade dress is similar to trademark, except it's going to protect the characteristics of the visual appearance of the product or packaging that signify the source of the product to consumers. It can also protect things like the layout and design of your website. So if you were to notice that someone copied you in your design, you could use trade dress as leverage to get them to cease and desist. While trade dress does fall under the umbrella of trademark law, it's not super typical for brand owners to actually register and protect the shape or visual appearance of the product with a registration. Though there are exceptions, Tic Tac comes to mind. They do have a registered trademark for the shape of the actual Tic Tac dispenser. So there are exceptions. It's just not super common. And trade dress is actually closely related to consumer packaged goods, which in and of themselves have unique legal considerations, and requires all, consumer commodities have to be labeled accurately. And so there are attorneys who actually specialize in this particular area alone and advise clients, especially, like e-commerce clients or anyone in a product distribution, what their, packaging must include, how it must include it, design factors, all of that. So in sum, trade dress is like a cousin to trademark.
Perfect. And then kind of thinking about marking, because to your point, you have to register to kind of give notice, but you also should mark. You have to mark with a patent, like this is protected by patent number, whatever. So for trademarks, for example, you should also mark with a TM or an R. So when do you use them? And is it okay to use either in some situations?
Yes, this is a really good question. And again, one that is frequently misunderstood by the general public. So the TM actually indicates common law trademark, whereas the R indicates a registered trademark. So, interestingly, you're only legally allowed to use the R if you actually have the registration. Otherwise, it could potentially be considered fraudulent. So both of them, but the R in particular, is meant to put others on notice that the trademark is registered and is protected. And I know a lot of brands struggle with the fact that, I don't want to put this on my logo. Do I have to put it there? Is it going to not make things look as pretty, but am I sacrificing my rights? The answer is, in sum, it's not absolutely necessary for you to do that. You're not like breaking any laws. You're not, negating your registration or your right to that trademark. It's just, from a brand protection standpoint, it's good to be proactive. And something I've noticed, because as a trademark nerd, I'm looking at like my shampoo bottles or my face wash, and some companies, choose not to at all, which is fine. And they have the registration. Others build it right in. Like the Crest 2 bottle has the R right next to the crest. Same with Target's Up and Up, little arrow logo, which is pretty ubiquitous. They have the R there, but others will put the TM, either because, their trademark is too descriptive, it wasn't worthy of actual protection, but they still want to say, hey, we have common law rights to this, or they're pending registration, kind of like patent pending. They may put that there to say, hey, we have common law trademark rights, but, we can't put the R there yet. So really it's from, it's the brand's, discretion, whether they want to or not. But it is recommended.
I really appreciate that clarification, because the designer in me really struggles with this from an aesthetic perspective, but the person who's heavily invested in intellectual property rights protection struggles with the other side of that. And so it's kind of this massive dissonance bomb that I have to deal with whenever we're rolling anything out, publicly. So yeah, thank you for that one.
Absolutely.
And actually, quick question, quick follow-up. Yeah. For clients that have products that are being distributed worldwide, where maybe they have trademarks in some countries and they have trademarks in other countries. I think we had a client a while back that had that problem. And I think they were advised at that time to do a TM on everything so they didn't have to change their packaging from country to country to country. Is that generally the recommendation, or how do you usually, just more for my own personal curiosity?
Yeah, I would say for a consistency standpoint, that would probably be wise. Especially once because you can use your US based trademark as a launch pad basically for your international trademark registrations. But once you send those out there, you can face a litany of different issues with various, country IP offices, office actions, different timelines, all sorts of things. So, I mean, it would be easiest and probably, most cost effective to just keep the packaging consistent and have the TM versus try to say, I have the R in the United States, but I don't in the UK or I don't in Canada. It's probably good for keeping things consistent.
Perfect. All right. Awesome. Last question in our background lightning round. And so this is more from a, growing curiosity of our own around the genesis of everything. And so we just did a historical deep dive on patents for our last episode. But copyrights have the same Article 1, Section 8, Clause 8 constitutional basis as patents to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And they similarly have a 1790 Act instituted by the very first Congress. So they've been around since the beginning of time, beginning of us. But when did trademarks come into play?
Well, in the United States, trademark laws didn't really emerge into the late 19th century. According to the USPTO, the first actual registered trademark was for Averil Ready Mix Paint, and it was their logo, and it was registered in 1870. And so then it wasn't until like 1876 when trademark law continued to grow and there were, penalties for trademark infringement. And the Lanham Act, which is the trademark law now, wasn't enacted until 1946. So definitely compared to copyright and patent, trademarks are relatively new. And this was, the main reason that trademarks came into existence was to fulfill public policy. And that was the objective of consumer protection. They want to prevent the public from being misled as to the origin or quality of a product or service. And so I think personally that this was probably not something on the radar, when our country was formed and the Constitution was drafted. Whereas, the founding fathers were a very inventive group of individuals, very artistic generation. And so I can see where they would specifically prioritize, copyright and patent, and maybe not think about trademark, back then there probably wasn't as many sources of goods, or you didn't have to worry about whether you were buying the right thing or not. And so that is kind of why trademark came into existence. So less of an artistic perspective, more of the consumer protection aspect.
Perfect. That's helpful. And that is, it's crazy to think how different in time they were, but it makes sense, as the global economy, or even just the national economy really, took off, became more of an issue.
Absolutely.
Well, it's also sort of interesting because, in doing this, I'm starting to see a lot more, parallels between the two systems than what I realized, or three systems than what I realized existed. And, with patents and copyrights, like there's a very clear quid pro quo between the individual and society. And it wasn't ever super clear to me what that was for trademarks, but the consumer protection side of that is that like societal good piece of it. So that makes a lot of sense.
Yes.
And it's sort of consistent with the broader ecosystem.
Absolutely.
Awesome. So I know that contracts are another big aspect of brand protection, and kind of out of scope for today's conversation, but it's super important. And so I think it's especially important for those of the audience newer to them, copyrights, and anyone considering outsourcing or working with contractors. So this is something we've spoken about at length as a sharp corner to avoid in our prenuptial patenting and our top 3 inventor mistakes episodes. and we're going to do it again here because it's that important. And we've, seen some, problems when people don't pay attention to this. So could you talk about who owns a copyright by default in both employment and contract scenarios, and the importance of a work made for hire agreement?
Yes, absolutely, because this is super important, like you said, and it's something that a lot of new business owners definitely don't consider when they're taking on employees or independent contractors. So under the law, in a traditional employee-employer relationship, the employer automatically owns any and all copyrights to work created by that employee pursuant to their employment. But conversely, when a creator is an independent contractor, the general rule is that the independent contractor automatically owns all of the copyrights created by that individual pursuant to their relationship with that business. So businesses should always utilize work made for hire agreements, which are meant to articulate copyright ownership between, the independent contractor and the employer. So with all of my clients, I always advise that they include a work made for hire clause in their general and independent contractor agreement, so that it's known up front that anything that independent contractor creates pursuant to this relationship is owned by that business. And so that business can then, go and seek copyright registration free and clear, not have to worry about the independent contractor disputing ownership. And this way, again, it's a good way for the business to build up their valuable copyright assets without getting into the weeds on who actually owns that.
Yeah, this is so real. And like we've seen software deals, busted up where, code ownership issues became a concern because, the code was developed by contractors and they didn't have a work for hire provision. And so, the contractor sort of owned the copyright to all the code. And, this is kind of another one of those like broader ecosystem pieces. Like you sort of learn both in patents and copyrights that the system is very intentionally biased towards protecting creation and inception of these ideas. And so it's not necessarily paying for or rewarding the payment of the creation, but the actual inception or creation of the idea or the work. And it's sort of a bonus pop culture piece that wasn't like sort of really on the agenda, but it came to mind the other day. There was a dispute a couple years ago over the Friday the 13th franchise, and Jason Voorhees. So this was the script for the first movie was written back like in the late 70s. They released the first movie in 1980. It was written by this guy named Victor Miller. And as you know, copyright law sort of changed in the late 70s around some of these things. And in 2021, Miller basically served notice to the production company for Friday the 13th that he was terminating the copyright on grounds that he created the script as a contractor and not as an employee. And so, the producers countered that no, you were an employee under some Screenwriters Guild, provisions. And, the courts took a look at it, it bounced around and, ends up in the Second Court of Appeals. And, they terminate the copyright for one of the 4 Mount Rushmore of horror films, right? Like that's how significant this is. Like we're talking about one of the biggest Hollywood franchises of all time sort of is falling into this snag. And now it's like, it's really going to kind of muck things up for them going forward because we'll get into kind of like the whys on some of this later, but these rulings can kind of be narrow and split things apart where, so like, he doesn't have the copyright to the title. He has a copyright to the, the camp and the mom, but like the mask, the hockey mask that's iconic, that came later, doesn't have the copyright to that. The adult version of Jason didn't come until later, doesn't have the copyright, to that. So now we've got this franchise that's sort of like split completely between two entities because of this level of contractual provisions. So it's like you can't overstate the significance of this for folks. It's such a like a little hidden thing that you just can't undo later on.
I agree. And it definitely, it does, break up that film series, especially because, in the first film, Jason's mom is the killer. So, as far as canon goes, and, with horror movies, you get further and further away from the original plot line. But, that was a big deal in the first film, that Jason wasn't actually the original killer. And so how does that look moving forward in new iterations? I saw that there's going to be a Camp Crystal Lake show come out. Can they even include Jason's mom after that? And so you're right. Not doing this up front, not having a work made for hire can completely undo the decades of work and presumed IP ownership. So it's definitely crucial to get ahead of it.
Absolutely.
Valerie, as not being a horror film, person, you should have said spoiler alert, because I didn't know that Jason's mom was the killer. Now I'm not going to watch it, because now,
Jason doesn't even show up until like the very last scene of the first movie. So
no, don't worry, Mary. I'm not
spoiler.
into it, so I wasn't going to watch it anyway.
Yeah. Well, that's good. That's like a classic trivia, who was the killer in Friday the 13th, and people often think Jason, but it's not. It's his mom. But he is afterwards.
Oh, now we know why. Clearly.
Yes.
I'll be sure to put a spoiler alert tag in the show notes for any other Ashleys out there, just in case.
I don't want to ruin it for anyone.
No. Well, thank you so much for those great explanations. I think that gives us like a super solid footing to help us kind of dive into some of these current events and some of the recent court rulings that I think are going to help bring some of these legal concepts to life. And some of them are also like pretty damn funny. So the first SCOTUS ruling that we'd like to talk about, because some of this was hilarious, hearing the Supreme Court justices try to address potty humor with straight faces, is Jack Daniel's Properties versus VIP Products. Can you tell us a little bit about this case, how it collided with claims around First Amendment freedom of expression and parody, how the Supreme Court ruled, and what the lasting implications could be for trademarks? And in doing so, feel free to be very detailed on the infringement specifics of the dog toy.
Oh, this is a great one to talk about. Not only because everyone knows Jack Daniel's, but dogs are an extremely important part of American life. And so this is super relevant to not only culture, but also copyright and trademark law. So high level, right, because all of these cases are extremely dense, but high level is that VIP Products created a Bad Spaniels squeaker dog toy that looked visually similar to a Jack Daniel's whiskey liquor bottle. Specifically, VIP Products created a squeaker toy that mimicked the shape, color, and design of your traditional Jack Daniel's bottle, with the black and the white font and the shape, but also replaced Jack Daniel's bottle phrases such as Old No. 7 brand Tennessee Sour Smash whiskey and 40% alcohol by volume with comedic alternatives like the Old No. 2 on your Tennessee carpet and 43% poo by volume. So
and 100% smelly.
100% smelly. And then, there's a dog like on it. It's hilarious. And I agree. It's always hilarious to try to see super professional, Supreme Court justices grapple with something like this. So very entertaining. So in addition, as we touched on earlier, trade dress is a protection. So, Jack Daniel's has trade dress rights to that whiskey bottle, right? The look, design, everything. But that wasn't what they ended up specifically suing for, because they actually own trademark registrations to their whiskey bottle label and design of the bottle itself. So they have a very wide portfolio of trademarks. So they took issue with VIP Products' usage of the whiskey bottle and sued for trademark infringement and trademark dilution, which is a similar claim. It's also under the Lanham Act, and it is instead asked whether the defendant harmed the reputation of the famous trademark as opposed to whether they infringed the famous trademark. So that they pursued both those avenues when suing VIP Products. And my inclination is that they were probably upset that they wanted some revenue, but also they could think, wow, I don't want them disparaging our brand by having 100% smelly on a bottle that looks like our whiskey bottle. So in defense, VIP Products' main argument to the claim of trademark infringement was that the dog toy was an expressive work and didn't designate a source of a good or service. And so they were insulated from infringement, and the standard of likelihood of confusion didn't apply. So very, very quick backstory, when courts are considering whether trademark infringement exists, if there is an issue of whether it is an expressive work, there was a different precursor test called the Rogers test that they often applied to determine, is this even being used as a trademark, right? Or is it just expressive? And if they found it was just expressive, oftentimes courts would stop the analysis there, foreclose the claim, not even consider the likelihood of confusion test that I mentioned earlier. So that's, a big part of this case. And in defense to Jack Daniel's claim of dilution, VIP Products has argued that it was a parody. The toy's a parody of Jack Daniel's, and therefore fair use. So both of these defenses in and of themselves resound in the First Amendment and what expressive uses can and cannot be made of trademarks, right? And so what the Supreme Court ultimately did here was that first, they determined VIP Products was using Bad Spaniels as a source identifier for their dog toys. And indeed, VIP Products conceded this in their pleadings, that, this was their trademark. They were using it to peddle dog toys, etc. So the Supreme Court said, well, this is a source identifier. This isn't expressive. There's no threshold First Amendment inquiry needed here. And therefore, only likelihood of confusion needs to be considered. So is Bad Spaniels confusingly similar to Jack Daniel's? And, skip the whole expressive portion. Further, the Supreme Court ruled that when a trademark is used as a source identifier, as they believed Bad Spaniels is, the statutory exclusion for dilution, which parody is one, statutorily included, you could be found not liable for trademark dilution if you're using it as a parody. However, this was a source identifier, and therefore those exclusions don't apply. So the Supreme Court really took those, First Amendment defenses off the table and redirected them, but also clarified what does it mean to really use a trademark as a source identifier versus what's expressive, and how do we analyze that? So, moving forward, my takeaway is that, there's no blanket rule for what, unauthorized use of a trademark and when that is parody and when that's fair use, just because it expresses a humorous message, right? You're not going to be insulated automatically. You should anticipate that a traditional likelihood of confusion analysis will always be engaged by the courts. You shouldn't assume that just because you're using it expressively that you can get away with it and you're not going to be subject to traditional trademark infringement. But, overall, those who make parodies off of trademarks should be treading lightly moving forward, and cognizant of potential liability because, they just don't know where that line is going to be drawn. And also, this conversely gives trademark owners probably more leverage against infringers. They could cite this case and be like, well, this parody wasn't found to be parody and therefore this is trademark infringement or trademark dilution. So that's really the big takeaway, is that, there's no rule for what is or what isn't expression and First Amendment protection when it comes to trademark infringement, and you should always be prepared for that liability.
Yeah, the source identification piece of this one was really huge. Going back to the kind of the fundamental stuff that you laid out, earlier. I think they said that that in the majority of the opinion, they said that the cardinal sin under the law is to undermine that ability to indicate the source of a good, right? And when it came to freedom of speech, Kagan said we hold that it's not appropriate when the accused infringer has used a trademark to designate the source of its own goods. In other words, has used a trademark as a trademark, right? That kind of use falls within the heartland of trademark law and does not receive special, First Amendment protection, because it's that brand confusion, misleading the consumer about where the product is coming from. That's where they really fell into a big, VIP fell into a big, trap on this one. And, rightfully so. With parody too, they said they should be amused by parody, but not confused by it. Right. It's sort of like hearken to that thing. It should make you think about that thing, but it shouldn't make you think that thing came from its original source. Like it should be, these things should be clear on its, on its face. I thought it was funny too. I mean, lawyers can try to do whatever they want to do, but VIP tried to argue that this was like a non-commercial expression. Which is hilarious. Like, so Kagan said this is a standard commercial product. This is not a political T-shirt. It's not a film. It's not an artistic photograph. Right? It's not like a thing that harkens to a thing. And then Justice Thomas, who's like always like really great for like pithy one-liners, he says, could you just elaborate a bit on why a product that you can buy online or at Petco is non-commercial? I mean, it's like it's absurd the argument was kind of absurd on its face, but
yeah, that is absurd. And like you said, this goes right to what we talked about, why trademarks are created in the first place, right? Yep. Protecting the consumer. They don't need to be confused about whether Jack Daniels made this dog toy, even though I'd like to give consumers, a more benefit of the doubt than that, but it's important. It's important for the purpose of the law to uphold that.
Yeah. Well, I mean, Jack Daniels does make dog products though, and sells licensed merchandise in the same market. So they do actually compete actively in that space.
That'll on remand, that will probably be something that the lower court considers when they're analyzing likelihood of confusion, especially if Jack Daniels has a registered trademark for dog toys. Then it's really going to get interesting. Right. So, but yeah, definitely that'll be a huge consideration. The overlapping use and the commercial aspect will be huge. My opinion, I think Jack Daniels will come out on top here.
Yeah, it seems like it. And I mean, this was pretty like resounding decision for a court that tries to stay away from, IP things in general, and then tries to not make very like bold, assertive claims about things related to IP. And then it was a unanimous opinion. I think you're right. All right. For the next question, I love this one. I think things are just starting to get interesting, but could get really freaky in the not so distant future. Strictly for podcast research purposes, and maybe that's a little bit of a lie. Back in February, I went to the theater and I watched a movie called Winnie-the-Pooh, Blood and Honey. This was a low budget horror movie. It featured a now feral Pooh Bear and Piglet. They've been abandoned by a grown-up Christopher Robin, and they're now out for blood trying to fend for themselves. Some college kids are vacationing in the 100-acre wood. Christopher Robin's returning with his girlfriend, and they get tangled up in Pooh and Piglet's murderous rampage. There are X's, chloroform, hot tubs. Pooh learns how to drive a car. I mean, it's a disaster. Disney owns the rights to Winnie-the-Pooh, and for added context here on the lengths that Disney has gone to protect its IP, here is a tour of some headlines. Disney forces Florida daycare center to remove unauthorized Minnie Mouse mural. Disney tells stonemason that carving Winnie-the-Pooh into child's gravestone would violate its copyright. Disney affiliate charges elementary school $250 for showing The Lion King at PTA fundraiser without permission. Why aren't films like Blood and Honey feeling the full weight of the fury of the mouse?
Yeah. First of all, I'm really happy you brought up Blood and Honey, because if my trivia knowledge of Friday the 13th didn't give it away, I'm a huge horror movie fan. Unfortunately, have not had the pleasure of seeing Blood and Honey yet, but it's on my short list. And
to, 'cause
as a Winnie the Pooh fan,
the sequel was already greenlit, so you need to make sure that
I'm thrilled. As a Winnie the Pooh fan from my childhood, it's like a beautiful mashup of like two of my favorite things, and I'm really excited about it. So, and I'm also excited you asked because it's a prime example of avoiding copyright infringement by using copyright protected material after its expiration. So, in general, and there are exceptions, but the general rule is that the term of a copyright is the life of the author plus 70 years after the author's death. So thereafter, the copyright falls into the public domain and it belongs to the public for the public to use how they see fit. So this means Disney, as you noted, Josh, a company that is notoriously aggressive at enforcing its intellectual property rights.
understatement.
Yeah, graves, daycares, you name it. There's no boundary they won't cross. And so they can't prevent a film like Blood and Honey from using Winnie the Pooh and Piglet. And specifically, it was the first Winnie the Pooh book, which includes 10 stories that entered the public domain in January 2022. So that means any of the characters really featured in there, Pooh, Piglet, Tigger, Eeyore, Owl, Kangaroo, all of them, they're free game and people can use them. And I actually thought I read that there was even another Winnie the Pooh horror movie or something, not necessarily a sequel, but people are using this and they're allowed to. And I think it is interesting though to note that when copyrights have a natural life expectancy, right? Trademarks aren't the same way. They can expire, but they don't necessarily have to, only if they're purposely abandoned, say they cease using it, right? They can't show use, so it dies, or it isn't renewed in a timely manner, accident, and it just lapses. But, for instance, trademarks have to be renewed between their 5th and 6th year, their 9th and 10th year, and then every 10 years after that. And the USPTO wants to see an updated specimen of proof that you are using that trademark for the goods and services you registered it for to begin with. And so, but in theory, especially if these are owned by businesses, which is a good idea to have rather than as an individual, it's good to have like an IP holding company of some sort. But it could go in perpetuity, there are trademarks that are probably 100 years old because the company is still in business and it still uses that trademark for those goods or services. So those are, not prone to the same public domain, situation that copyrights are.
Yeah. And just like we saw the Jack Daniels case too, as long as it's not perceived as coming from these companies, that's another key element to it too, right? Can't be any of that brand source confusion. Still have to occupy those lanes, safely. But I don't, from having watched Blood and Honey, I don't think there's any confusion at all that came from Disney. There's some other notable, interesting ones that are coming up soon from my research. So Mickey, who market researchers have acknowledged is more well known than Santa Claus, is going to be coming up for one of these himself. Actually, later this year, there's the Steamboat Willie version, the little short cartoon that's appearing at the front of the intros of some of the Disney cartoons. Apparently, that's going to be public domain later this year, and then early versions of Popeye, King Kong, Donald Duck, Flash Gordon, Porky Pig, and Superman are all going to be entering into the public domain at various points over the next decade.
I think to your your Friday the 13th Jason thing, again, it's that, and you were kind of saying it too, it's the early version, right? Keeping within the confines of what was actually at that time. So like, I think you were mentioning, Josh, the Winnie the Pooh of old didn't have the red shirt, for example, right?
Correct. And like Mickey, in the the Steamboat Willie version is the version of Mickey Mouse that's coming out, but that didn't have like the rounder kind of more playful, approachable version with the red shorts and the white gloves. Like all of those elements were added later on, so that stuff's going to be safe, for Disney for an extended period of time.
Yeah. And as I think we discussed even with Steamboat Willie, with the copyright falling into public domain, they still have a trademark for that little short snippet that they'll play at the beginning of some of Disney movies. And so I'll be interested to see, hypothetically, someone tries to make a use of Steamboat Willie. I'll be intrigued if Disney tries to take the trademark infringement angle instead.
Yep. Yeah,
Given
well, and I think
the answer is probably yes.
Yeah.
Right.
100%, they'll do everything. They'll try it all.
Clearly there is precedent. Yeah, I mean, I think this is going to get really interesting too with, creator culture, the likes of Instagram and TikTok combined with increased superpowers that we're being given with the, these generative AI and deep fake tools. Disney's not going to be able to go after everyone, right? At least in theory, but, more on that in a bit, little teaser there. So next up, we're going to talk about another important aspect of trademarks. Makes them unique when compared to other creative expectations around things like patents and copyrights.
So this one centers around a trademark trial and appeal board, or TTAB, decision from earlier this year around musical artist Lizzo's trademark for use of 100% that bitch on apparel. She has a line in a song called Truth Hurts that goes, "I just took a DNA test and turns out I'm 100% that bitch." She admitted that she didn't create the phrase, but had seen it in a social media meme about being 100% that bitch. I think I ever said much.
I'm probably gonna bleep it out, so it's all good.
That's fine. Personally laughing a little. And then added it to the song she was writing. So her original registration was refused on the grounds that it was a commonplace expression and a well-recognized sentiment, but she won her appeal with the TTAB. So on what grounds did Lizzo win the appeal, and how was she able to get a registered mark even though she didn't create the phrase and then the phrase was pre-existing?
Well, as you mentioned, Lizzo was denied initially by the examining attorney because they felt 100% that was just a commonplace phrase, as opposed to, again, a source identifier of apparel like shirts that Lizzo was trying to sell. And so, Lizzo appealed to the TTAB, which, for those unfamiliar, it is essentially the trademark office's internal tribunal in which trademark disputes can be adjudicated beyond just, going back and forth with an examining attorney with an application. So Lizzo, is allowed to appeal by right. And that's important. Even if you don't think, you could not have a very strong argument for, appealing a final refusal, but anyone can do it, right? So if anyone who has a trademark application, if they receive a final refusal, you have a certain amount of time where you can appeal that decision to the TTAB and have them, determine whether or not that refusal stands or should be overturned. So, but she appealed, basically arguing that fans and consumers associate 100% that with her and not just with a commonplace phrase. Relatedly, I find it very interesting that up until very recently, there was a prohibition on immoral and scandalous trademark protection. And so words like weren't allowed to be trademarked at all. This actually came before the Supreme Court with a trademark called FUCT. So it sounds like, it sounds like one word, but it's spelled differently. And so, but the Supreme Court ruled that prohibition actually violated the First Amendment, therefore opening the gates to, swear words being able to be trademark registered. So, before 2019, Lizzo wouldn't have been able to get this trademark at all, just on the face of it being immoral. But now, she did get over it being a commonplace expression. And what the TTAB ultimately did, they looked at all the evidence that Lizzo had provided, which was 100% that being used on clothing, keychains, mugs, stickers, all sorts of goods. And all of them referenced Lizzo in some way. All of it was connected to Lizzo. It wasn't just 100% that floating around on its own, like it's commonplace. It was Lizzo's 100% that, and so that is how ultimately the T-Tab said, this isn't a commonplace phrase. People associate 100% that with Lizzo, and therefore she is entitled to trademark registration. And even though she didn't coin the phrase herself initially, she is still allowed to do this. She did give writer's credit to the individual who initially coined 100% that. She gave writing credit on Truth Hurts to her. So, in essence, the Lizzo, it's associated with Lizzo, and she is allowed to register it.
It'd be a really interesting exercise to look at how many profane marks were registered post 2019.
That would be. I would like to see the statistics on that. I bet someone has run them too.
Oh, I'm sure.
I bet it was like flooded.
Also, in my research for this one, I saw that Supreme Court decision referred to as the fucked decision, which, like, I've never laughed so hard in preparing for a podcast episode in my life as I did for this one. Because I mean, you could argue that a lot of their decisions could be called that, but this one actually got that designation, so that made me very happy. So. Also, I found this one particularly interesting because, as we're sort of juxtaposing some things, against contrasting with patenting, where obtaining and defending patents centers so much around, the first claim to the creation, around the existence of prior art, things like that, trademarks are in this case are like really about consumer perception versus creative endeavor. And that was just sort of like a, thing I learned. I would like to shift our attention next to where mine often goes anyway, and that's Reddit. But more specifically, what can happen when the lines around where your brand begins and ends aren't clear? So I suspect a lot of people listening, even if they're not on Reddit, have probably heard of WallStreetBets subreddit, and if they haven't, sure they've at least peripherally aware of the meme stock craze that it gave rise to. An individual by the name of Jamie Rogozinski, he created this subreddit back in 2012. It got wildly popular during the pandemic when his members sort of banded together and employed some aggressive trading strategies to squeeze hundreds of millions, if not billions, out of short sellers. Big win for the little guys by pumping up the value of stocks like GameStop. Rogozinski published a book called WallStreetBets and also filed for the trademark. Reddit responded by booting him as the moderator, citing that he was attempting to monetize a community, and then immediately filed for competing registration applications for the same mark. Proceedings are pending before the T-Tab, and Rogozinski is also suing Reddit in federal court for infringement of his unregistered mark, violations of contract, all the things along that line. This matter is clearly unsettled, but folks out there should what in fact should folks out there be thinking about when they're depending on big platforms like these, and even when considering smaller partnerships where brand ownership and monetization lines can very quickly get blurred?
Yeah, this is a great question, and one that I think primarily resounds in contract. And my advice, if you are planning on using a major platform to grow your brand or to monetize in any way, is to read the terms of use. And that sounds like a joke because they're humongous. And it's a joke that's been played out by South Park as far as Apple's terms of use, and Black Mirror made fun of Netflix terms of use recently. And so, it's a joke because they're huge, but it's actually important. And I'm not saying you need to scour every, nook and cranny of these terms of use agreements, but you do want to look for important provisions such as content ownership and things of that nature. So, and there are several reasons why these terms of use are important in this regard. When you're using, say, a Reddit, a Facebook, a Twitter, an Instagram, a Threads, et cetera. So first, when you're using a platform like Reddit that is primarily built upon user-generated content, meaning users can post content, create subreddits, contribute, all on their own. There are moderators, but it's pretty much you can upload it and it's there. And so in that situation, you're almost always granting the platform a license to use your content that you upload to the platform. So, while you may own the copyright to your content, for instance, the Copyright Office recently did introduce a new copyright class where you can, register your whole, thread of your whole scroll of your Instagram posts, and you can have a copyright registration to that, or like your blog posts, for instance. Instagram can't own that, but they can use it, and probably in their terms of use, there is a license to, obviously at least display your content, because that's what you're doing. That's what the platform does, right? But you'd be surprised. Some of them, it may be, it's a royalty-free license to use, display, do whatever. They could most likely, use you in some sort of advertising. There are multiple scenarios that could unfold. So it's important to know that aspect. Also, second, there are always community guidelines when you're on a platform like this. So with rules, restrictions that surround your posts and interactions with others. And so my understanding is, Reddit is claiming they, axed this individual because he violated the terms of use. And so that is something that a platform will definitely use. If they feel you're in the wrong, they can boot you, they can block you, etc. So when it comes down to this, I always recommend to not actually build your brand on these platforms, but just use it as a brand tool to grow your brand, right? For instance, if you're going to start something, it's always a really good idea to start with a website. Start with a website, have that be the basis of where your brand is born, and then take it to the other platforms, so that there's no question that it belongs to you, right? And I haven't scoured Reddit's terms of use in particular, but my guess would be they, are saying they own the subreddit titles, or you know what I mean? All these things. And so I will be super intrigued to see how this pans out, because it could really impact, how brands are established moving forward, especially if this goes against Reddit.
Yeah, I mean, it's gonna be a big precedent setter, for sure. And also, thank you. I didn't know we were gonna get to work South Park in today too. But now,
Oh yeah.
but now I'm gonna have the human centipede stuck in my, which you can't unsee that. You can't unsee that.
No, but anytime I click through, I'm like, oh gosh, what am I agreeing to with these guys? It definitely made you think. But it was really interesting when I don't know if you've seen the most recent Black Mirror, but they basically Netflix made fun of itself, calling itself Streamberry, and it happened so that the girl that the story's about, Netflix basically appropriated her life and made a show about it. And she's like, you can't do this. And they're like, you agreed to this in the terms of use when you signed up. we could do whatever we want with you and your image, your likeness, your life. And so she had like no recourse at all. And so it's unfortunate. They're huge, but if you're thinking about who owns what when it comes from an IP standpoint, the terms of use are imperative.
Yeah, and like most things, Black Mirror, it sounds terrifying, but also not too unlike what you'd expect to come out of reality. So yeah, there's that.
No, it walks that fine line, and it actually spooks me.
Yeah, it's like definitely eye-opening. And for all these reasons, like I'm really surprised this didn't become a bigger issue sooner, right? Like massive brands are being created by these influencers on these platforms, and there's this inherent symbiotic relationship between the platforms and the creators. But what that means for brand ownership feels like it's going to get pretty sticky and could be, huge topic of debate going forward. So next up is another of the 3 landmark Supreme Court cases on IP this year, and it centers around a conflict involving one of the biggest music legends of all time and the best-known painter of the pop art movement. Like we discussed earlier, copyrights protect original works of authorship. This includes things like photographs and paintings, and this protection also extends to the author, the exclusive right to create what are called derivative works. before we get into case specifics in Warhol versus Goldsmith, because I feel like this one is a little bit heavier than some of these other cases, could you explain what constitutes copyright infringement, what derivative work means, and like briefly what the infringement exceptions are under fair use doctrine?
I'd love to, because it is especially relevant here. And so as we did mention earlier, right, as a copyright owner, you're given exclusive rights to your copyrighted work, right to reproduce, distribute, display, perform, and or create derivative works, as you mentioned, Josh. And copyright infringement occurs when one or more of these exclusive rights are infringed without permission of the copyright owner. And in general, to establish copyright infringement, again, in federal court, if you have your registered copyright, the copyright owner, i.e. the plaintiff, must prove, one, they have ownership of a valid copyright. Recall, you have to have your registered copyright to sue. And two, they must prove copying of the protected elements of the work by the infringer, which is the defendant. So if there's no direct proof of copying, which is most of the times the case, it's hard to prove, it's hard to say, like, I know for a fact that you copied this, right? Instead, the question becomes, the plaintiff must prove the defendant had access to the copyrighted work, which is very easy, especially if it's proliferated, widestream media. And two, that there was a substantial similarity between the general ideas and expression when compared to the copyrighted work. And that, multiple factors can come into consideration with substantial similarity. But that high level is the standard for copyright infringement. So because copyright owners have the right to creating derivative works, that is something that comes into play. So in a derivative work is an expression or creation that includes major copyrightable elements of the first previously created original work or the underlying work. So the derivative work becomes a separate second work independent from the first, but it's still related in heavy copyrightable elements to the first. So we're thinking translations, say your book is translated into Spanish, that's a derivative work, and that's a copy, you own that copyright as the copyright owner, or cinematic adaptations, musical arrangements, etc. I saw a good example that, say, especially in this day and age, a comic book can be the underlying work of a copyright, and then, they can spin off into a movie, a TV show, all sorts of different related derivative works to that original comic book. And so that is an exclusive right that the copyright owner has. So it's important to know is that you can create those derivative works. But as we touched on briefly with Jack Daniels and trademark, copyright law also recognizes fair use as an exception to infringement. So, a lot of times the question will become, is this a derivative work or is this fair use? Fair use generally includes things like criticism and parody, comment, news reporting, teaching, scholarship, research, all those types of things. And when considering whether fair use applies, courts are always going to consider 4 factors. And that includes, the purpose and character of the use, including whether such use is of commercial or nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect upon the use upon the potential market or value of the copyrighted work. So big picture, the question a lot of courts ask is whether the use is transformative and essentially transforms it into something new that in and of its right is a fair use of the original copyright.
Yeah, and that turns out to be pretty key to this one. With that baseline down, could you talk about the Andy Warhol Foundation for the Visual Arts Inc. versus Goldsmith case, what the Supreme Court ultimately decided, and what the lasting takeaways could be for fair use in derivative works?
Absolutely. So this hits right on the head of fair use, particularly the first element, which I will explain in a little more detail. But high level facts, because facts are everything when it comes to these cases. Backstory here is that, Andy Warhol had created a series of 16 works featuring prints, the Prince series, as they were called, which were all derived from one copyrighted photograph taken in 1981 by Lynn Goldsmith, who was a professional photographer. So originally, there was Andy Warhol only paid a license to Goldsmith to create the one, purple silkscreen portrait of Prince called the Purple Prince, which was featured in Vanity Fair's 1984 issue. So after Prince died in 2016, Vanity Fair's parent company, Condé Nast, approached the Andy Warhol Foundation, since Andy Warhol had since passed away as well, about recreating the image for a special issue to commemorate Prince. And, the AWF had all 16 of these that Andy had created, back in the early 80s. And so the magazine ultimately featured Orange Prince, which was one of the 16 he created. And instead of being a purple silk screen, it was an orange silk screen over the image. Goldsmith was unaware that all of these 16 derivatives had been created. So when she saw the Orange Prince in Vanity Fair, she took issue with this, considered it copyright infringement, because she had not licensed this particular use. So the primary issue before the Supreme Court here was the first factor of fair use, meaning the purpose and character of the use, including whether such use is commercial or nonprofit, and whether the work was transformative. So the Andy Warhol Foundation argued that Orange Prince was transformative because the silkscreen images of the photograph have a different meaning or message than the original photograph did. But the court ultimately disagreed and found that this factor weighed against Andy Warhol Foundation because Warhol had originally paid a license to the photograph to create Purple Prince, and therefore the use was commercial, right? He paid to use the photograph and then then sold the photograph to Vanity Fair. It's all commercial. So the Supreme Court actually said, such licenses for photographs or derivatives of them are how photographers like Goldsmith make a living. And so they provide an economic incentive to create original works, which is the goal of copyright. So in the ideal world, the Andy Warhol Foundation should have also gotten a license from Goldsmith to create all 16, but especially Orange Prince, if they were going to be providing it to Vanity Fair for publication. And so ultimately, the Supreme Court ruled that Andy Warhol Foundation's use of Orange Prince was not fair use, and therefore it was copyright infringement, which is, a big deal because, the Supreme Court doesn't always take hard stances with intellectual property cases. And so this is, interesting that, they are saying this is an infringement as opposed to we're going to remand this to the lower court for you to determine if this is infringement or not, right? Sometimes they don't engage in that analysis. But the majority opinion essentially opined that to hold otherwise would potentially authorize a range of commercial copying of photographs to be used for purposes that are substantially the same as those of the original. As long as the user somehow portrays the subject of the photograph differently, he could make modest alterations to the original, sell it to an outlet to accompany a story about the subject, and claim transformative use. So they're saying, this is going to be a slippery slope where maybe you don't even pay the license, or you just get one license and you perpetually create, you change the color of it and then you claim this is fair use. And so the Supreme Court is taking a stance where they're protecting the original creator here. And that is a major takeaway of the case, is that this will give copyright owners more leverage for infringement suits, especially if it's something as, simple as a color change or slight modifications to the original. But it will make it much more difficult for other creators to navigate what they can and cannot do with pre-existing copyrights and fair use. So, and it's never been a bright line, but there was a case once upon a time where changing of the colors and slight variations like that were enough for fair use. And so now that's not going to be the case. And so it will help set that precedent and guide it a little more, but I think it's definitely creator favorable. And but there were dissenting judges in this case, and they basically went to the point that this would impede the creation of new art and music, thwart the expression of ideas and attainment of new knowledge, because part of art in of itself is, inspiration, right? And this is something that actually is going on with the music industry as well right now. Robin Thicke and Pharrell got sued several years ago for Blurred Lines by Marvin Gaye's estate. And essentially, Marvin Gaye and Pharrell indicated that, we've heard it, we're maybe inspired by it, but it wasn't like we sat down and copied it. But they were found to be copyright infringing, and there were a ton of briefs submitted from people in the music industry that basically said this could create dangerous precedent for the music industry, because where is that line drawn? Sampling is abundant, using similar, tunes and rhythms, that's abundant. What is copyright infringement, what is not? And so there's been this like a proliferation of major artists like Katy Perry, Taylor Swift, Lizzo getting sued for copyright infringement based upon works that pre-existed them, which often they never even heard before.
I think the court put some like really important nuance in their wording on this one that's going to hopefully keep that from being an issue, because not a lawyer, but my read on this is they said, look, if you're not doing something that's substantially different than the original and it's of commercial nature, okay, we need to put up the flags and give this a close look, because in the majority opinion they said those sort of fair uses don't supersede the original objects or supplant them, rather they work to serve a different end. So it's kind of like it's almost like the trademark of a trademark thing in the Jack Daniels case. It's like you're almost sort of overriding another brand or another use. You block the original artist's ability to use that thing that was uniquely theirs. You're not hearkening to it with a parody. You're not bringing it to someone's imagination. You're literally overriding it and stamping out their ability to commercialize their creative work. And that's a huge distinction. And I like layman read on that. I feel like they were pretty clear on that, because like they said, the consequence of this would have been huge, right? Like allowing small alterations to sort of change the fair use application would, I think the words they used, it would like swallow the rule and, make it so that, the exclusive rights to prepare derivative works would just like basically be eviscerated. And if you wrote, you talked about, books being adapted to the big screen, that's a significantly, when movies hit the big screen, they're significantly different than the books we read. But you can't argue that that's transformative enough to take that right away from the author of that book or that script originally. So, I feel like this is a really important ruling, and I like that they offer distinction around the Campbell's soup can.
Okay.
Pieces that Warhol had also done, because now we're talking about the same artist. We're talking about another commercial application, but they said, look, this is an entirely different purpose, right? Like Warhol's not selling soup, right? This is like commentary on consumerism. So where sometimes I feel like they like leave these big wide open questions that do more harm than good. I felt pretty good about this one.
Actually, you do make a good point in that regard. And in my opinion and experience, the first factor in the commercialism versus non-commercialism has always been like one of the biggest tipping factors when it comes to fair use. And I agree, right? This will nip a lot in the bud as far as, how am I using it commercially, and like just like basically only altering it slightly. I more think, it's always kind of fluid as to how much is enough, how much isn't enough of a change, right? But I think that this will at least give that guidance that silkscreen color over the photograph isn't enough to change it, and you're using it commercially. And you're absolutely right. The Campbell's soup distinction is big because, right, Lynn Goldsmith was doing the same thing as Andy Warhol was, is selling the photo, right? Andy wasn't selling soup. So I agree. So I think it'll really dampen a lot of potentially infringing activity that could have occurred otherwise. But I'm always interested to see more parameters get established around how much is enough change to make it transformative.
Yeah, and then what the lower courts do with the dicta and all that stuff. Yeah.
Exactly. Because almost all the case law is created in lower courts, Supreme Court only hears a very, very small fraction of all the cases that tried to get in there. So
my one nitpick with the mental gymnastics that happened in this one, though, was they tried to justify their Google versus Oracle ruling on fair use earlier, last year-ish. Time is not, I don't know, but they said that Google copied a ton of Sun's code in sort of replicating the Java interface, and the court reasoned that it was created for use in desktop and laptop computers only insofar as it needed to include the tasks that would be useful in smartphone. That is, Google put Sun's code to use in a distinct and different computing environment of its own Android platform, a new system created for new products. And that's like pretty garbage reasoning, if you ask me, because that would be like, oh, if Andy Warhol had like done this online instead of in newspaper or in a magazine, it would have been okay. So anyway, I felt like there was sort of some like similar ends justify the means mental gymnastics required to get to that conclusion that they put into the original case. But just a plug here, in season 2, we did an entire episode on the Google v. Oracle case and its implications on fair use for software. So not going to relitigate all that today, but highly encourage folks to go and give that one a listen if you're curious on the specifics of that one. All of that said, this fair, I'm sort of like a little bit more passionate about this one, I think, probably than some of the other ones. It's like I personally find this fair use stuff to be the most kind of confusing and paralyzing aspect of copyright law from like a creator's perspective. So, we try to keep our content fun, entertaining, culturally relevant. Sometimes that means trying to, tie in elements of pop culture where we can, right? Like to use memes and GIFs in blog posts. And sometimes we like to do screenshots from movies and webinars and sound bites in the podcast. But we consider this podcast to be news reporting, commentary, criticism, hopefully educational in nature. I don't think it would create any brand source confusion. And while we're in the top 25% of podcasts across all categories, I don't think we're going to adversely affect anyone's, potential market for their copyrights. But, that threat still looms large, and it definitely it can for sure stifle the creative process. And the Warhol case definitely seems clear to me, but I think in a lot of cases it seems like the bright line almost maybe like it doesn't intentionally exist, because I think that would make it easier for people to cheat, but it also makes it really hard to comply when you can't possibly know how to follow the rules. And as long as the price of getting it wrong is Disney going after daycare centers, you have to care.
I agree.
That's not a question. That's just me on a soapbox.
No, I am an intellectual property attorney, and I get nervous about what I'm using and where and how. I pay when it comes to like my website, and graphics. I pay a license for business purposes, which is important. And also I want to share memes. I want to, share music on like Instagram, stories, for instance. But I'm like, am I infringing the copyright by doing that because I'm a lawyer and technically this is promoting my business? Is it commercial? I agree. It's very paralyzing from a creator standpoint, especially because I don't want to, I'm like, am I going to be the joke of an IP attorney that gets popped for copyright infringement because I thought I wasn't crossing the line and I am,
Right.
So, it's almost impossible as a creator, as anyone these days, to like avoid it altogether. I mean, at least every business should anticipate some sort of DMCA, Digital Millennium Copyright Act takedown getting sent to them for an image on their website, unless you're just like completely tight shit bottled up. It happens to everybody in some capacity, probably, but I agree. I mean, and that's why it's a fair use factors, right? It's always going to be that balancing analysis, and until someone gets sued that's in a similar position as you, or the case law continues to get carved out and more defined, those parameters are going to continue to be very blurry and scary at times. So the most you can do is just be very cognizant of it. And like I said, the amount and substantiability of the copyrighted work used is a factor considered. So if you're using like a really small part of something and it's part of your much bigger creation, then you have much less to worry about. But the flip side is there's almost always an argument why you're using it fairly. So, there's always, I'm the lawyer, my husband goes crazy. I'm always like, well, on one hand and on the other, and I'm like, I can't help it. I'm programmed to think this way. But, I always think, there's always probably, unless you're just so egregiously infringing, there's almost always an argument why you could be using it fairly. So.
Absolutely. In any case, it's hard to imagine this decision not having an impact on our next and final topic, especially as it pertains to what it means to be sufficiently transformative, and especially in a commercial context.
Perfect. Thanks, Josh. So, generative AI systems like ChatGPT, to me, seem like the next gold rush. We dealt with clients in AI and ML for the last decade, but this whole large language model and how ubiquitous it is now, it seems to me like the next gold rush in terms of technology. And it's going to be probably a legal IP minefield for a lot of companies and developers. So some AI experts are arguing that as soon as 2025, 90% of online content could be generated by AI, which is crazy and stifling. So this is no longer the stuff of academic research. It's not science fiction anymore, although it's, harkens to it. And the biggest players in tech are pouring billions into it in an arms race to reshape the internet. And it's already raising some really serious concerns around content ownership. So just from a brief background, these generative AI systems use large language models, which are trained on massive public data sets that include websites, books, images, and articles. And then the chatbots are then able to create an unlimited amount of new content, which is quite impressive, including articles, essays, images, lyrics, video, code, you name it. And they're going to, and they're doing so at a level of quality and artistry that it's hard to distinguish it from human created content. So when prompted, at least in earlier versions, ChatGPT admitted that this training data included copyrighted material, but claimed this work was okay because of fair use. So the content it's producing is certainly the kind of content that people have traditionally sought copyright protection for. And so, can generative AI output be copyrighted? Is it really legal for these generative AI companies to be training their models with these mass volumes of unlicensed copyright protected material? And what does it mean for the average consumer who's taking the generative output and using it without a license? That was thick.
Well, you're right. AI is definitely probably the gold mine of technology. Kind of scares me a little bit. Especially as a content creator myself. I like to write. And I've seen a lot of lawyers talk about how they're using ChatGPT or Google to draft their blog posts now, things of that nature. So it's relevant in every sector of society. And so as of right now, baseline, no, generative AI output cannot be copyrighted. And so, currently the copyright law only recognizes copyright for human creations. Only humans can get a copyright registration. Indeed, there was a case that held that a photograph taken by a chimpanzee couldn't be copyrighted because the chimp's not a human. So with that as the baseline, it would be a very, very large stretch to say that a machine of any sort could be the owner of a copyright. However, it is a big question, by scraping libraries of content that include copyrighted material. Are these AI companies committing copyright infringement? They could be, especially but it's difficult then when the output is you can't decipher what comes from where and how much is a copyright infringement or not, so this could turn the fair use analysis on its head. For the average customer, say, someone who's like, create me a blog post, right? Are they exposing themselves to copyright infringement? Potentially in some capacity if that AI is using copyrighted material. So this is all extremely dense and complicated. And a lot could hinge on whether, as AI continues to proliferate, whether the Copyright Office ultimately decides to, recognize a mechanism for AI generated content, either, specifically excluding it from trademark protection, saying, no, this door is closed forever. It is still just only human creations that can be protected. Or are they going to allow where, so when you do, say, for instance, you create something that uses part of a copyright of another, you do have to disclaim that, so it's like, do people have to note on their copyright registration application, oh, I used AI to create this, is AI somehow still an owner of that? Or I don't own what the AI created, but how do you know what amount it created? And so, or they could ultimately change it, like where AI is an author, the AI itself actually gets credit for the copyright. It'll be interesting to see how this all pans out because, I'm no AI expert, but I mean, if you're using, copyright protected source material, I can only imagine that some sort of copyright issue will arise here eventually.
Yeah, I think it's going to be answered. I mean, the patent system is grappling with this, and I think it's going to be continuing to be, the whole Davis case that started in Europe and whether AI could, be an inventive entity from a patent system perspective. So I think it's just going to be, I think it's far from resolved in the patent world and also just starting to be dug into in the copyright world. So, yeah.
Yeah, and I mean, regulators tend to be pretty slow to catch up to these things, but this one is especially tricky because, it's potentially obfuscated infringement, right? Like you've got these models are consuming the collective of human knowledge, including like a lot of unlicensed copyrighted material. They're synthesizing new answers from that material. These companies didn't create, but then these answers, this new content is being hid behind a chat interface that doesn't have to cite any of its sources, right? So it's like this big black box. It's just sort of magic. So it's going to be, I don't know, it's going to be hard to regulate this stuff. It's going to be hard to prove. It's going to be hard to prove some of it. And from a usage perspective, we looked at ChatGPT's terms just for our own internal use because we were trying to, figure out, how it could potentially impact us in terms of content generation, especially. And one of the things that I found to be like particularly eye-popping is that the terms say that it's okay to use the content for commercial purposes, but what sort of like viral transference of infringement could come from this, right? Because the terms explicitly say that you own the output, right? And that you can use it for commercial purposes, but it also shifts any infringement liability to the owner of the generated content. So like they're assigning rights that they don't have, and then they're saying, well, you own the input, you own the output, and it's on you to make sure that this complies with local laws. So like by using the interface, you are like going back to the whole contract thing, the terms of use, you are explicitly inheriting the infringement liability that come as a user, which not a big deal if it's just your little chat assistant on the side. But if you're using this for like marketing material and blog posts, like this is a whole nother, potential can of worms. And it's going to be interesting.
Yeah, well, I mean, and from, Chat GPT's perspective, it's genius. That's genius contract writing for them. Hey man, we're not liable for anything. It's all you. And that's great for them. But I would suspect, I mean, something is going to come up with them specifically involved in the IP sector, and whether those terms of use are legal to do that. It'll be very interesting. I agree.
Josh, I think your point too about, assigning rights that you don't own, right? And so I think if I, again, not being in that world as much, but in the patent world, it happens, right? Where you can't, you have to have a good chain of title. And if there's a break in it, and then, then rights are being assigned from an entity that didn't have the rights to assign in the first place, right? And so I could see that being a huge chink in the armor. Well, it's like, if you didn't own the rights to begin with, and now you're giving them to whoever, the person who's using ChatGPT, well, maybe like you should have been given those rights away anyways, because they weren't yours to give. So anyways, interesting.
Yeah. And, going back to the, some of like the Warhol stuff and, fair use, commercialism and all that. There's Getty Images. They have this massive database of images, especially used in the media. They're suing Stable Diffusion right now, saying that Stable Diffusion trained their image generator on Getty's 12 million images without getting permission or providing compensation. And if you want to talk about a work that's designed to supplant the work of someone else for commercial purposes, as in the case of Warhol, I think you can start making pretty strong arguments to that, to that extent.
For sure. And it is seriously a new frontier for everyone from every angle involved. And so, I mean, I'm just along for the ride to see how it works, because I'm still hesitant to use it myself. Yeah. So yeah. I would be looking at the terms just like you too. So
yep.
It'll be interesting.
The one thing that I think is sort of interesting from an authorship perspective, though, and like the not being able to credit AI as an author, one of the arguments they're trying to make is that, like the office is basically saying like, hey, if you can use AI tools for creating original works, it's just like using, you can use Photoshop to edit an image as a photographer, and like you can still get a copyright for that. Sort of some of the logic driving that distinction is saying that like it matters to the extent that the human is involved in the creative process. And they're saying that, because ChatGPT is this, like you put a prompt in and then you get an output, that you're not sort of involved really in authorship, right? And so this is like this AI generated thing that's not, eligible for copyright. But where I think that starts to fall apart a little bit from a logic perspective is that not everyone uses these interfaces the same way, right? There's a sort of a lot of developing science around getting the best possible answers and outcomes from these systems. And, there's an iterative, these generative AI systems, they have memory. You can sort of make them smarter as you go through this like iterative process of prompt crafting. And, it's hard to imagine that there's not some artistic expression in that, right? Like you and I are not going to get the same thing out of ChatGPT. So I think, again, like some of these arguments, like I don't think they're really going to stand the test of time once the regulators truly understand what these things are capable of and how people are actually using them.
Definitely. And I was thinking that too. It's user controlled, right?
Yeah,
you have to prompt it. You have to explain to it what you want.
That's right.
And so, yeah, I would argue that that's some sort of human contribution. So, wow, that would definitely probably could be an angle that's explored in the case law, because, yeah, or how much is enough? Again, it'll probably be perhaps a factor in net-based analysis or a sliding scale of some sort of, did you have enough human, contribution, or was it all just the machine? Or yeah, it's a fully loaded topic. And I have no clue exactly how it will, all pan out. But yeah, for right now, it's pretty set in stone that only humans can create copyrights and own them. So
Yep. Yep.
yeah, whether having AI as an assisted tool in that creation, just like you say, Photoshop or any sort of other, like music editing software, is that the same? Is that akin,
Yep. Yep. And then just to shake things up and play devil's advocate, because AI probably is the devil. I was thinking models are trained on the collective of public human knowledge. These LLMs, they make connections and they generate new works. When does that depart from how humans learn, become inspired by, and synthesize from protected works, as we have no doubt done today?
Well, and it's similar, and that was the argument that was made in the patent case, that the AI, the database system, had come up with, solved its own problem by itself and engaged in inventive activity, but still wasn't enough from the court's perspective across multiple countries. But that might change.
Yep. All right. Well, I think that covers it and then some. Thanks, Mallory, for joining us today and making our very own greatest hits tape of 2023 copyright and trademark news. And hopefully you'll be able to represent us if the mouse comes after us for the graphic I'm going to let Dolly generate for this episode's promotional materials.
I got your back, Josh. And it was so much fun being on the podcast today. Thank you both, Josh and Ashley, for having me and letting me engage in this discussion on brand protection with you.
Thanks, Mallory.
Awesome. All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.